Good evening. This is Environmental Law. You're with John Milburn. We have a special guest tonight, Mr. Sean Ryan, who is the Principal Solicitor of the Environmental Defenders Office in Queensland. Sean leads the organisation's major cases for a number of things, including the Galilee Basin. Sean has worked for government departments and private consultancy before entering into private practice at Cause Chambers, where he was for 6 years before joining the Environmental Defenders Office in 2011. Having worked in a level of governments in the past and a range of industries in relation to environmental issues, Sean brings a very broad perspective to assisting the community and public interest at the EDO. Sean has degrees in law and environmental science, as well as a master's in environmental law from University of Queensland. It is with great pleasure that I now introduce Sean to you. Thank you, Sean. Over to you.
Thanks, John, and thanks for that intro. And good evening, everyone. And very pleased to have you all here virtually as it is. So John asked me when he sent through the request, one of the topics was the theme of obstacles to environmental law. And I thought a bit about some of the, certainly legal barriers like standing. But to be honest, from my, experience, particularly in the last 5 or 6 years in community practice, I think one of the biggest barriers is money. So I want to talk a little bit about money. But I'm also happy to be flexible if people want to direct the conversation in a certain way. I was also thinking about, what I wanted to hear when I was going through law. Most of you going through law, or as a second degree or a first degree, or can I get a sense of where you are in the legal? Oh, so first, and are you late in the degree or early?
Sorry, in February I start the final year, and also a Bachelor of Arts Criminal Justice in February.
Okay. So you're all looking to go into private practice in the next few years. Is that about right? I'm getting a few nods. So, okay. So, one of the things I think that doesn't get talked about in law school that I thought I'd touch on for a start is salaries and earning powers and that sort of stuff. My knowledge is definitely a little bit scratchy and out of date, but I thought I'd give you a potted overview to help you get a sense of wages, and that I think will then relate later when I talk about the costs to the community. So, when I was a graduate lawyer, I, was very pleased to get about 40,000 when I came out of law school. That was in 2005, so people hopefully get more than that these days. And in a few years, in 5 years, I got up to about 140,000, which was pretty good as a senior associate, I thought. And if I think stayed down that pathway, and if I'd been lucky enough to make it to partner, certainly at some of those large firms, the partners earn about $1 million a year, or can do, for equity partners. I don't know what barristers bring home if you're looking at going down the barrister path, but I do know what they charge. And junior barristers can charge sort of 3,000 to 5,000 a day, or 300 to 500 an hour. And senior barristers can charge 8,000 to 10,000 a day in Queensland. And certainly more in Sydney, and I think Victoria as well. I've certainly heard of senior barristers charging 20,000 a day, which is quite extraordinary when you think about the Australian average wage, which is about 70 to 80,000, I think. So certainly the legal career for people who go down that path can pay quite well. But my experience has been that there's not actually a close relationship between earning power and happiness. And certainly a lot of people earning quite high salaries are very stressed and have difficulties maintaining relationships. It can be a lot of hard work, and that's one of the hard truths of the practice of law. It can be very intense and quite draining. Most of you would know that the legal profession has not a great history of depression and substance abuse and over drinking, and it's I think from my direct experience, it is common because we work in quite a high pressure environment. So I've certainly found, and I think the research supports this, that there's a diminishing returns when you get above the Australian average wage of 70 or 80,000, and I'm sort of about that now. When you go beyond that, the happiness doesn't keep getting better. It's sort of there's diminishing returns. And I certainly know that when I went from private to community practice, my pay halved and my happiness doubled. And I think one of the reasons for that, at least for me, is because I think law at its core is a service industry, and it's helping people. And I think as humans, I think you often get the most joy when you're helping others. And you certainly get a lot more joy than just looking at dollars in your bank account. But there's another more important aspect or flip side to those higher salaries that I want to be the focus of what I talked about tonight, and that's access to justice. Because we're not just investment bankers. We perform an important function in civil society as being the gatekeepers to the rules that govern society. So the amount we charge helps determine whether people can access their legal rights and understand their legal duties. And I think that's a very important consideration. And so what I'd really like to do tonight is actually step through a practical sort of real world example of a piece of planning environment litigation, a hypothetical piece of environmental litigation, and step through the various considerations in terms of costs from the community perspective, or if you're going into private practice, from your client's perspective. So I thought there's probably two paths I can go down that I'm familiar with. One would be the planning law path, so looking at the impacts of a commercial development or shopping centre in an urban context. Or the other area I'm familiar with that I'd be happy to talk about is looking at resources law and environmental conflict, such as a mine in a farming area. Do people have a preference of sort of which sort of path they'd be more interested in exploring?
Farm and mining.
I was hoping someone would say that, because that's very dear to my heart, particularly at the moment. Yeah, I was sort of thinking, and is anyone living on a farm online tonight? You are, Liz. Oh, great. Oh, look, you're going to be very, helpful for this discussion, I think. Imagine you're on a farm, and I want you to try and put yourself in the shoes of the person potentially impacted by this development. And so think about, how much you could afford, or what you personally would do. So for a lot of mines, the first notice you get of a mining proposal or a mining lease, and probably a little bit of background law. Have you guys done resource law? Any nods? No, not so much. Okay, I'll give you a broad overview of some of the resource law major approvals in Queensland. And it does get quite complex because there are quite a few, but I'll just touch on the major ones. So if it is a large project, like larger than $50 million or so, which most of the big mines are, it's most likely to be a coordinated project under the State Development Public Works Organisation Act, which is the worst named act in Queensland and doesn't even abbreviate well, SPIDWA. And that's basically the preliminary approval, or the project level of approval, that a mine requires before it can then proceed to its next two major pieces of state approval, which is the mining lease, and that grants the tenure over the resource, because obviously the coal belongs to Queenslanders, and we have to grant a license to a private company to exploit our coal for profit, for which we get royalties in return. So that's the mining lease, is the tenure. And then sitting over top of that is the environmental authority under the Environmental Protection Act. So those are the three sort of major steps for large mines. State Development Works Public Organisation Act, which is the Coordinator General, makes the approval under that, and then the mining lease and environmental authority. Now, the mining lease and the environmental authority are heard together. So just quickly stepping through that, you might have, if you're in a farming community, you might get notice through the newspaper, because I'm sure everyone fastidiously reads the public notice sections of the newspaper every day. I don't know how anyone finds out about these developments sometimes, but anyway, let's assume you're lucky enough to say, oh, there's a proposal for a mine in your area. And then if you go to the website, you'll see there's a environmental impact statement. Now, the submission period for an environmental impact statement is about 30 to 60 business days. So you might have 2 months or so to consider what is often thousands of pages of technical documents. And look, it can be quite hard for the community to get a sense of what the impacts are from those proposals. You might want to engage a consultant, but consultants can cost a lot of money. In my experience, between $150 an hour and $400 an hour, you're averaging around $250 an hour. So it can rapidly get very expensive because they certainly can't read thousands of pages in less than a few hours. So you're looking at a few $1,000s to try and get a consultant to give you advice if you're, say, concerned about the air, dust, noise. But let's say you get that or you don't, and you put in a submission. Now, currently in Queensland, if you don't put in a submission to the EIS, you may lose the right to lodge an objection to the approvals later on. If you're unhappy with the decision with the Coordinator General approval, this project level approval, it's important to note that there is no statutory judicial review. So judicial review is excluded from that first level approval. So you can't challenge the legality under the Judicial Review Act in Queensland, nor is there any merits review. You can't challenge whether or not it was a good decision. So if you're unhappy with what the Coordinator General says, you pretty much don't have much of a choice about that. The next opportunity you may have to have a say about it is when the Mining Lease and Environmental Authority come up for a submission. And again, you might find out about that in the local paper, or if the property, if the mining lease is over your land, you'll probably get a notice about it. There's also an archaic provision, and I'm pretty sure it's still there, which is that the mine has to put notice on a datum post, so it's like a survey post within the mine boundaries. And I've had some farmers send me these hilarious, fields of green in the middle of nowhere with this tiny little post and an A4 piece of paper nailed to it, and that's the notice for what in that circumstances was a 21 million tonne a year thermal coal mine. So massive projects can be quite hard to find out about them. But, let's say you do notice that there's a submission period. You then would have to put in your submission within that 20 business days in order to get the right to object to court later down the track. So let's say you put in your submission, and then you get a decision, and the decision is approval. So this is when you get the opportunity to object to the Queensland Land Court. Now, the Queensland Land Court is a court in name, but it performs for mining leases an administrative function. It makes a recommendation at the end of the day. So it's not a court with judicial proceedings, or at least not for mining lease objections. So it's a little bit different from the Planning Environment Court that John was mentioning earlier, that some of the judges he works with sit on. So now to the nitty gritty. So you've, let's say you have all these concerns. You might be concerned about dust, air, noise, perhaps even climate change if it's a thermal coal mine. You can put all these in a submission, but the mining company will have had the EIS in all that material. So in order to really carry any weight, you'd need to bring experts. Now, as I was saying, experts can cost, let's say, $200, $250 an hour, and it can certainly take a few days for them to prepare a preliminary report, a few days to prepare an individual report. Often in these proceedings, you get directions orders that require the experts to meet and form agreement. So there's time for them to participate in an expert meeting. And if their evidence is contested, they'll have to show up in court. So I find that often that will take about 100 hours, more or less. So it can cost $20,000 per expert. Now, one of the main concerns when you're thinking about objecting to a mine might be, you might be aware that in some jurisdictions there are costs. There are costs orders that you have to pay the other side's costs if you lose. Now, most of you would be aware that in the higher courts, such as the Supreme Court, costs follow the event as a general rule. So if you lose, you are presumed to pay the other side's costs. Now, in the Planning Environment Court, For many years, it was an own cost jurisdiction, which means that the presumption is you pay your own costs, which I think is appropriate in a matter where it concerns the public interest. Development, like mines, affect the environment we all inhabit. They're a matter that we're all concerned about. It's not purely about private interest. Now, for a few years under the former government, that changed to a cost jurisdiction where the presumption was you, under most circumstances, pay the cost to the other side. And that has a very chilling effect. So if you're sitting there, lodge your objection and you're thinking, shall I proceed with this litigation? One of your considerations is, well, if I lose this litigation, I have to pay the other side's costs. Now, if the other side, it has one of those top barristers we were talking about before at $10,000 a day, and they have one of those top law firms with partners on very high salaries and senior associates, etc. You know, they could clock up quite a lot of money. And one of the ways of breaking down the costs of litigation, a rule that I think generally holds true, is it's about a third solicitors, a third barristers, and a third experts. So, you know, you could quite easily, for the other side, spend 200,000 on each of those and incur 600,000, and it doesn't take much to get up to $1 million or more. So, you know, if you're the average Australian earning 70 or 80,000, that would clearly send you bankrupt. So that's a chilling effect. So one of the things you would want to do is consider what your prospects of success are. Because if your prospects of success are very good, you might think that risk of paying the other side costs are very low. But in order to get a prospect of success, you'd want to engage solicitors and barristers yourself. Now, you probably couldn't afford the top end of town. Yeah, absolutely. Some of the farmers, particularly in Western Queensland, are drought affected. They've been in the hock to the bank for quite a while. So, you know, not even the Australian average wage is probably looking good to them at the moment. So, you know, it's really quite difficult. So, you know, what do you do? And most of the top firms work for the large companies, and if they're not directly conflicted, because they already act for the large companies, they don't often take small or low-paying matters. If you could gather some money together, you might get one of the mid-tier sort of firms or the boutique firms that have more reasonable costs, but they're still going to be in the hundreds of thousands, I'd say, typically. So, you know, most people would find that very difficult to afford. There's a few services out there. Oh, I should say there is quite a noble tradition amongst lawyers of providing pro bono practice. But in my experience, that pro bono practice is typically limited to small pieces of advice or maybe one-day appearance in court. But planning and environment litigation often involves complex evidence, and that requires quite a lot of time in court, can easily go for weeks. And most solicitors and barristers just can't afford weeks out of their time for free, the private ones, within their pro bono capacity. So there's services such as QPILCH, Queensland Public Interest Law Clearinghouse, and they can put people's name on a list that firms can take up to try and get within the pro bono capacity. But if you're not taken up by any of those, then you're looking at places like Environmental Defenders Office, where I work. So we're a community legal centre, not for profit, and at the moment, until we've been promised to get some money back from the government, but for the last few years we've been entirely on community donations, and at the moment we're 100% community funded. So we have very limited funds, but we can take on matters where there's a significant environmental benefit. We don't do matters where it's a private interest. So if it was a shopping centre at the end of the street that ruined your view and kept you awake at night with noise and light, that's pretty bad, and I feel sorry for you, but that's not, if it doesn't have an environmental impact or environmental benefit, it's not within the mandate of my office. So it's really quite difficult for people to be able to afford those costs. But let's say, and so for some, and we have been acting for some farmers, and currently we're acting for Oakey Coal Action Alliance, which is a group of farmers in the Oakey region who are opposed to a mine called the Ackland Stage 3 mine. I don't think I'm committing sub judice by disclosing what is that. Is very public information. You can look that up on the internet. So, look, we're providing our services pro bono. Now we have to fundraise and get money from other people to pay for our time to help those people. But you know, that's one way of doing it. We don't tend to have a problem with conflict of interest of our donations. I kind of wish we did. All of our donations, they don't tend to come from mining companies or large law firms. You know, we often joke around that the large law firms should send us a Christmas hamper every year because they must make a lot of money out of the litigation that we help the community run. Hi Joe, so my CEO is just walking past. Let's say you're lucky enough to also have, let's say the Ackland mine clearly is a thermal coal mine. It's got climate change impacts on threatened species and all sorts of things that are sufficient that we're able to take that matter on. But it's still difficult to then get a barrister, and this is a situation we've been in quite recently, because if barristers charge $10,000 a day for that one was set down, by the way, for a 10-week hearing, so 50 sitting days. So 50 sitting days at $10,000 a day, $500,000 just for a barrister. Do you have to use a barrister? That's a good question. You don't, and you could even be self-represented. But my experience, and certainly I think the court was saying to me this morning, the Queensland Land Court, is that self-represented litigants find it hard to navigate the rules of evidence, what's hearsay, what's not, and also knowing the right questions to ask of witness. Cross-examination is certainly a fine art. I'm not very good at it, and I know barristers who are very good at it, and certainly senior barristers. They charge very high rates, but the reason why they can charge high rates is because for commercial clients, they're worth it. You can extract concessions from a witness if you know the right questions to ask, or you can, destroy your opponent's witnesses by, showing the logical fallacies in their reasoning. And that's a very difficult thing to do on your feet. And so I have great respect for barristers. And I always try and get a barrister, and I always try and get a senior barrister, because the mining companies or the large developers, they will almost always afford a senior counsel. And so you're just outclassed if you bring a knife to a gunfight. Help you hurt inside knowledge of the way I might have to click on. Yeah, it does help if you have inside knowledge. It helps if you have contacts and friends too. So if you have networks with particularly experts, if you find you've got within your circle of friends and contacts, you can often get introduced to experts and convince them to do some work for free. So you can certainly reduce your costs a lot that way. I often try and get barristers to work on a capped fee agreement. So at least that you pay them something, but they have an upper limit, so that takes some of the risk out for the community groups. Also, I find that more and more I have to help community groups set up donation pages and help them do media, and media is something that's very tricky when you're in court. Conservation and land management certificates, is that certs? I'm not sure what certs are. Help with representation.
Sorry, certificates. It's just abbreviated certificates.
I don't know what that is. Sorry.
Sorry, I've done conservation and land management, Cert 1, Cert 2.
Oh, okay.
Half of a Cert 3, and it's with the Indigenous Education Centre.
Right.
And you learn about the different species and for the specific area, and have to work out projects for land management. So
Yep.
I didn't know if that'd assist, having that sort of a background with representing people.
Yeah, it hasn't so much come up in the ones I've been involved in so far, but certainly that sort of background helps. I find my science degree helps because environmental law is often quite technical, and it involves a lot of science and natural resources and that sort of stuff. So I think that would help in your understanding and advocacy. But in terms of the experts, we often it's more like geotechnical expert to understand underground water flows, or resource economists to understand the relative values of agricultural land to mining land and that sort of stuff. I like the comment about sausage sizzles at Bunnings. I find, it's funny, I got into this to do law, and increasingly I find myself sort of fundraising and begging for money, and our EDO is running a swim for the reef in January. We're going to have a swimathon to help raise money. All the crazy things we do just to bring in sort of the money so that we can, it's funny, we deliver the services to a client that we don't charge, and then we have to sell those services to people who pay but don't get the service. It's a funny business model, but it's how it works. And look, one thing I can say is I think crowdfunding is really changing the dynamic a bit. So we've worked with GetUp, and GetUp do an appeal, and they've got 700,000 people on their email list. And for one of those matters, I think it was publicly on a website, they got 17,000 donations of 10 or 20 bucks. But and each individual donation is not much, but when it adds up, that enables us to run cases, and we ran a couple of cases against dumping on the Great Barrier Reef, which were part of, I think, what contributed to the eventual ban on dumping on Great Barrier Reef. So can be remarkably effective. But you're never going to get the millions that the companies will have to run their case, but you can get the tens, if not hundreds of thousands, that you can, if you convince a whole bunch of barristers and experts and whatnot to work for free or at limited rates, you can start to afford it. So I think I've covered solicitors, barristers, experts, what else? Transcripts. Oh my gosh. I'm going to try and contain my outrage in relation to transcripts. So one of the things you'll find essential when you get into litigation is having an accurate record of what was said in court. And I'm sure John will know this from criminal cases. When you're cross-examining a witness, often, and it goes over multiple days, often you'll need to put back to them something that they said on the previous day, and you need to put it very precisely, because if you want to catch them out when they've conflicting themselves, or they've got their story wrong, you need to be able to say, well, but excuse me, sir, yesterday you said this, and that can be devastating when you're doing cross-examination. But you can't do that if you don't have an accurate record of what was said in court the previous day. Now, up until a few years ago, transcripts were done by the State Reporting Bureau, and the courts and the government had the ability, if you didn't have any money, to provide you with a transcript. And there was also quite commonly transcripts were shared amongst the parties, and certainly they shared the costs. Now, the former government thought it would be more efficient to grant a monopoly to a private company to provide transcripts called Ausscript, and they charge the applicant for the transcript, and they charge about $2,000 a day. It varies depending on how long the day is, 1,500 to 2,500, but let's say $2,000 a day. So let's take the Ackland matter, 10-week hearing, 50 hearing days. That's $100,000 in transcripts. $100,000 just to get a record of what was said in court. They charge that to the applicant. They also charge that to the court. The court has to pay for the transcripts. And our client, the farming community, or the average Australian, I don't know, who can afford $100,000 in transcripts. Now, we can apply to the government for a fee waiver due to financial hardship. But even if the government grants us that fee waiver, then the government has to pay Ausscript. So, and in my matter, there's up until today, now there's I think 12 level 2 objectors. If they're not allowed to share the transcript, so if they each want a copy, that's $1.2 million for Ausscript to press print on their printer. So I think it's a real barrier to access to justice in Queensland, and it's something that I'm personally quite livid about right at the moment, and I'm going to try and keep myself to there because I'm already sort of going a little bit over time. Yeah. Yeah. So, and I should get back to cost awards now. In the planning and the land court, costs are at the discretion of the court. So it's always a risk that you could get costs awarded against you. But at least in the land court, if you run your case quite efficiently, you don't run a lot of issues that are of low weight, and you don't waste everyone's time, but you bring experts on the strong issues you have, then your costs, in my experience, are quite low. The cost risk, I should say, is quite low. I have had costs sought against my client in the Wandoan matter, Strata versus Friends of the Earth. In that case, we successfully argued that that environmental objector was acting in the public interest and testing an important principle of law, and the court declined to grant costs against my client. There was another matter even where in relation to the Alpha coal mine, where one of the objectors who was successful in relation to the groundwater concerns, so our client as well as some of the other farmers raised concerns about the accuracy of the mining company's groundwater model, and the court accepted that the groundwater model wasn't sufficiently reliable outside the mine lease area. So we were successful on that point, and the objector actually recovered some of her costs from the mining company. So it can go both ways. But more often than not, because the mining company spends so much more than any objector, the costs favour the mining companies and tend to have a chilling effect on litigants. Now, I think someone mentioned earlier about banding together, and certainly that's one of the important ways of getting through this sort of litigation. When you think about each individual only having, say they have the Australian average wage, it's very hard to individually run litigation. But when you can form a group and you can pool resources, then it can make it more manageable. If there is an environmental group that's established and is concerned about the issue, it might be willing to risk its own existence by running the litigation, and the cost order would send the company insolvent, send the environmental group insolvent, basically kill it, but it wouldn't take the homes of everyone who runs it. So when you're a personal litigant, if you can't pay, the mining company ends up foreclosing on your home and you lose your family home, or at least an environmental organisation, it may cease to exist, but it doesn't personally affect the people behind it. It's complicated. Oh my gosh, complicated because everyone has their own agenda. Yeah. I mean, everyone's individuals, and certainly when you've got a large number of people concerned about a project, they're concerned about it for different reasons. Some people are concerned about light and air, and some people are concerned about climate change, and some people might be concerned about traffic. And so it can be quite a job managing litigation with multiple parties. But unless a large number of small people sort of come together, it's very hard to take on a mining company or developer with very deep pockets. So I think probably that's the end of my sort of cautionary tale of costs. How much it costs approximately to establish an environmental community legal centre? Oh, that's a good question. It actually doesn't cost much to form an environmental group per se. There's a few different ways of forming environmental groups, and most of them under the Incorporated Associations Act. And I think there's registration fees of, I don't know, I think a few $100s, but not thousands. And then there's obviously ongoing requirements in terms of having annual general meetings and all that sort of stuff, and submitting financial statements, getting audits. But it's not unreasonable or unmanageable. You can also form what's called a company limited by guarantee, which can be set up faster but is slightly more expensive. So there are various options. To be a community legal centre, however, that has a bunch of additional requirements. So we're a member of the National Association of Community Legal Centres, and we need to be that so that we have insurance through that community legal centre network, because obviously, like any law firm, we need professional indemnity insurance because we give legal advice. So you need to have that insurance cover in order for us to have practicing certificates and act as lawyers. But then to comply with the Association of Community Legal Centres, you then have to have a bunch of risk management procedures, policies, confidentiality, all of things you'd expect of a law firm. That's more onerous and has some costs involved. And I don't actually know those costs, but that gives you a sense of what would be required to set up a community legal centre. Okay, well, I'll leave it open for a couple more questions before I sort of wrap it up. I did forget to cover filing fees. Some of the court fees can be expensive in different jurisdictions. The land court, not so much, but certainly when you go to the Supreme Court or the Court of Appeal, I think it can cost about $1,000 to commence proceeding. Maybe John's more familiar in that jurisdiction than I am, but can be a bit of a shock when you go up to court, and even to get through the door, you've got to fork up hundreds, if not thousands of dollars.
Thank you, Sean. Is most of the work done by EDO involved in merits appeals, acting on behalf of submitters in relation to impact assessable developments?
Historically, yes, but recently it has changed. So it's kind of interesting. When we were 100% government funded and we didn't have to worry about so much where the money came from, we just dealt with inquiries as they came through the door, and most of the inquiries and the most common issue that arises for people is planning environment development, and that, as you say, is typically impact accessible development in an urban area under what was Integrated Planning Act, and there's the Sustainable Planning Act, and it's probably going to be called something different very soon. That was our bread and butter, although we did do some environmental enforcement, and we did the first injunction under the Environmental Protection Biodiversity Conservation Act, the Federal Act, to protect a flying fox. We also did an injunction, and I think it was one of the first, if not the first, under the Nature Conservation Act, again to protect flying foxes. Both those were before my time. But yeah, certainly the majority of the inquiries we helped with in the public was planning environment litigation, and that's what led to us creating the Community Litigants Handbook as a sort of guide for communities navigating the planning environment court. But a couple of things happened, and they're kind of related to the resource boom, sort of 5 years ago, and we started getting more and more inquiries to deal with coal seam gas and mining companies, because increasingly there's resource conflict between farmers, Indigenous people, landholders and environmentalists concerned about mining and climate change impacts, and those fossil fuel expansions. So increasingly we got called to do that sort of work, and we did. But I don't want to say correlation or causation. At the same time, the government decided that it no longer wanted to fund the Environmental Defenders Office. So we lost all our government funding. Now, I'm sure that they would have hoped that meant we'd go quietly into the night, and we were quite afraid that that's what would happen. But we were incredibly surprised and pleased that community donations have come forward, and a lot of people have supported what we do. And in some ways I found that a bit validating, because it wasn't just us that was concerned about helping these people, it's other people putting their hand in the pocket to give us money to help someone else. And I don't know, I feel kind of good about that. I kind of find that quite rewarding. So we have done a lot more of the resource work in recent times, a lot of mines, and a lot of merits-based, but also judicial review. We're currently in the federal court for the Australian Conservation Foundation against the Adani Carmichael mine, and that's a judicial review. So we do a fair balance of merits and judicial review. Judicial review, and I should point out, is much easier than the merits-based type of litigation that I was talking about earlier, with the complexity of experts. Judicial review can be done in a couple of days with barristers and lawyers and without experts, and it's much more easy to convince a barrister to take that sort of case on.
So perhaps
I believe. Okay, see you, Peter. I'm going to decline to answer the question about government and conflict of interest.
Sean, if I could ask a similar question, but put a different way. At the moment, in terms of the court work which EDO is involved in, where does EDO spend most of its time? In which courts, dealing with what type of issues? What are the range of types of courts?
Yeah, at the moment we spend probably the majority, and it'll probably only just be the majority of time in the Queensland Land Court, because that's the court that deals with mines and coal seam gas. We haven't been in the Environment Court, quite unusually, for probably a year or two, whereas that's the court we were most commonly in. But we do. So we've had some judicial reviews. We've just completed a judicial review in relation to the Alpha coal mine in the Supreme Court, which is now in the Court of Appeal, obviously still the Supreme Court. And we had a number of cases in the Federal Court in relation to judicial review, mostly under the Environmental Protection Biodiversity Conservation Act. But we also had a matter in the Administrative Appeals Tribunal, which concerned a sea dumping permit, and that was a related approval to the dumping on the Great Barrier Reef. There was sort of a bunch of related litigation that went on up there. In recent years, we also had some enforcement actions in the Federal Court in relation to the Paradise Dam and preventing the death of the endangered lungfish. So yeah, there's certainly a range of courts, but we do find, and it's mainly because the ones in the Land Court are merits-based, that they just take up so much more time. We might have a larger number of cases that are judicial review, but the smaller number of merits take up, far more effort.
And does the Environmental Defenders Office become involved in enforcement hearings under the Sustainable Planning Act as well?
So one of the things I should point out was we run an advice line, a community advice line, where we try and give free advice to anyone who rings up, where it has some sort of environmental benefit flavour, but we just try and give short, sharp pieces of advice to help people. So there aren't matters that we can take on as cases and run acting for them, but we often get people who are concerned about, say, tree clearing or destruction of habitat, or heritage buildings. Another one quite commonly comes up, and people will call us and say, I see something happening, is that lawful, or someone's trying to do that. So we haven't been on the record in the last few years that I can think of in an enforcement proceeding, but I can certainly think of matters where we've helped people or advised people of that being an option through the Sustainable Planning Act. Certainly seeking declarations can be powerful. A method of enforcement, because obviously you can't take someone to court and send them to jail or get a fine, but you can often get an enforcement order to stop them doing whatever the damaging works is if it's unlawful.
So are there any standing issues that people should be aware of when it comes to applying for an enforcement order or seeking declaratory or other relief, say in the P&E court? My understanding it's pretty open now for people to bring those sorts of proceedings. Yeah,
last time I checked, and you've got me on the spot, it was any person I thought could bring a declaration proceeding for a matter that should have been done under that act. So you're nodding, so I think that might still be the case. Certainly it gets more difficult for judicial review matters. You often have to show that you're a person interested or a person aggrieved. In the Environmental Protection Biodiversity Conservation Act, that standing is extended for community groups that have performed environmental actions or research within the last 2 years. But people might be aware that the current federal government has a policy of removing that extended standing because they got quite embarrassed when a community group took them to court and found they hadn't complied with the law in relation to the yakka skink and ornamental snake. They hadn't considered the conservation advices. So I think it's quite an odd response of government when they are acknowledged to have not complied with the law to then seek to change the law and prevent a standing for groups who might challenge them. But there you have it. That's the current policy of the national government. So, but generally, you have to show an interest above and beyond the ordinary member of the community if you're running public interest litigation in judicial review type proceedings. Certainly, the land court is more open, and any person can object, although there have been some threats to that. And yeah, the standing provisions do change depending on the approval and the act of the jurisdiction.
Thank you. And you've been very generous with your time, Sean. Michelle has a question about how much time you spend preparing as opposed to the time that you spend actually in court.
Oh, that's an excellent question, and one I neglected to cover. So there are some basic rules and rules of thumb when I sort of try and estimate how much time and money something's going to cost. And I often say that it's at least 3 times the number of hearing days is the preparation time. So if you have a matter that's 2 days in court, you'd expect at least 6 days sort of, sorry, 3 times, so 6 days in total, including the 2 days, so 4 days preparation. And that's a good rule of thumb, particularly for barristers. But if you're a solicitor, you'll probably end up spending more than that, like 5 times the number of hearing days. It's sort of something in that attitude, order of magnitude. For big merits cases, like for this 10-week hearing that we have in March, we will have 2 or 3 solicitors working full time for 3 or 4 months. So it takes a huge amount of time because there's huge volumes of material, thousands of pages of EIS documents. You work with experts who are quite detailed and technical and have to prepare reports. There's a lot of documents you have to prepare in terms of notifying the other side of what your issues are, putting the statements together, putting submissions together. It's I don't know how any self-represented community member can meaningfully comply with it. I have it full time as a job. I'm lucky enough to get paid for it, and I find it at times overwhelming. So it takes quite a lot. You have to be pretty committed, I think, to run litigation. It's not something anyone takes on lightly.
Thank you. Tony has a question about a hit rate.
I mean, that's always a difficult one. I mean, I'm going to be a lawyer and say it depends how you define win and depends how you define loss. I think we have some success, at least half the time. So, for example, in the Alpha coal mine case, we ran about 4 issues. So, climate change, economics, groundwater. Actually, we had a few people on climate change, so I think that was it. And we kind of lost on climate change, and I say kind of because the court found that it wasn't relevant under as a consideration of environmental harm under the Environmental Protection Act, but it was relevant as a matter of public interest. So that did advance the law somewhat, but the court ultimately found the emissions will be caused by another proposal if the mine proceeds. So if we don't do it, someone else will, the sort of drug dealer's defence. So didn't ultimately succeed as an issue, but there was both an incremental improvement in the law in that it was deemed relevant. There was also an incremental improvement in the finding of fact, because he found that 0.16% of global emissions was a significant and real and of concern, were his words. So whereas before courts had been saying, well, emissions from any one project are a drop in the ocean and not really significant on a global scale. So, we thought that was an improvement, although we wouldn't call it a win. So we sort of won on groundwater, half won on climate change, and didn't really win at all on economics. So I don't, in some days I call that a win, some days I call that a loss. But what I can say is that it's hard, it's really hard. I mean, I had 6 years in litigation and private practice, and I think we had a good hit rate there. I think so certainly 60% or so. I mean, one thing I've got to say is you're never sure of the outcome when you go to court. It's something that no one undertakes lightly, and when you get to court, usually both sides think they've got a good chance of winning, which kind of means it's anyone's game when you go into court, and I find it really hard to predict the outcome. And certainly my hit rate in community sector is definitely lower than private sector, just because I can't afford the same experts and barristers and transcripts and all the things that I had at my fingertips when I was into working for big companies, and that changes your prospects. And I find that a bit disheartening because I don't feel like it's a fair fight. But you know, that's the system we work under at the moment.
Sean, if
oh, sorry.
You're right, Tony. After you.
No, the reason I asked is because I used to work for a government or a couple of government organisations in the electricity and the water industry with long-line linear infrastructure.
Yep.
And, you know, those community environment groups, they just look at them as basically a pain in the ass.
Yeah.
You know, and they, you know, like they're just a little speed bump they eventually get over. If anything, it more or less, the project 9 times out of 10 will go ahead, but it just delays it by a year or 2 years or something. So yeah, no, I was just interested, you know, what your win-loss ratio is or whatever, you know.
Yeah, it is tough, but you know, like the case against Adani in the federal court previous to the one we lodged was clearly successful in that the approval was cancelled. I guess you might say it's unsuccessful because the government just approved it again. And I think there's something to be said for the statistic that I think it's less than 2% of development proposals ever get refused. So look, it's enormously difficult to stop development, and there's a lot of things going against it. But if you're the affected person, and certainly linear infrastructure can be, you know, when it comes to the linear infrastructure going through your farm or your house, you tend to be pretty concerned about that. And, you know, for those people, it can be everything in the world. So it's quite important to them. And certainly we deal with some affected landholders where, you know, and it breaks my heart, particularly the farmers, when they've been on the land for 120 years and their grandfather came to the land and they've been making, you know, a good go of that land, and now it's going to be, you know, gobbled up by a mine. You know, it's pretty hard to say to them, well, that's progress, you know, or, oh, well, they'll get some short-term mining jobs out of it. You know, I don't feel like there's a lot of balance in the consideration given to the community. But yeah, I worked for large mining companies and developers in private practice, so I know how it's viewed from the other side as well.
Thank you, Sean. And you've been very generous.
Actually, sorry. Okay.
Been very, very generous with your time. And could I just thank you very much for what you've provided to us, which has been gratefully received. And we very much appreciate your efforts in that regard. So at this stage, I'll bring it to an end. And thank you very much, Sean. All the very best.
Thanks, John.